Oregon license. I'm Joe Moore, CEO, host and co-founder of Psychedelics today, and joined by my friends Lizzie and Raza Lawrence from Zuber Lawler. Raza, can you give us a little introduction to yourself?
Yeah, hi everyone. Thanks for joining. Just a short background about myself. I've been doing mostly cannabis-related law since 2009, helping clients navigate through all these interesting federal and state law issues. And I've also worked over the years in the psychedelic space, but there's been limited stuff you can do in the legal context for psychedelics up until recently. Now it's exciting to see all these opportunities opening up. Seems to be maybe a psychedelic renaissance that's coming along, and I think people's minds are finally starting to open up to some of the harms of big pharma and the way we've been doing things, and the benefits of more natural plant-based remedies. So it's exciting to be here watching this sort of birth of this new legal industry. And before we get into these nuts and bolts, I just wanted to give a disclaimer that I believe we're required to give as attorneys. As cannabis licensing started and states started legalized cannabis, lawyers started to have questions about whether they could even work in this space, because they're essentially helping clients violate federal law, which has severe criminal penalties. And various ethics opinions have come out regarding cannabis and the kind of duties and obligations of attorneys. And they've said basically we're allowed to advise clients on compliance with state law issues as long as we always make clear that what they're doing violates federal law. And that does violate federal law, what we're discussing here today, Oregon system. It's analogous to the cannabis legalization that's been popping up in, I believe, a majority of states around the country now, where the states are explicitly approving and licensing people to engage in activities that are a blatant violation of federal law and have severe federal law penalties. So it's sort of an unusual space that we're operating in, where you have explicit approval from the state, but it's still completely illegal under federal law. We're going to get into a little bit more about those implications, but we have to make clear it does violate federal law, and we're not, as attorneys, we're not able to take steps to help you conceal federal law violations, but we can certainly help you navigate these state laws and become state law compliant. And also just wanted to make clear the views expressed here by the panelists are the personal views of the panelists, not necessarily the views of their respective companies or firms or clients. And no one should take our comments today as providing any type of advice, including financial advice or legal advice. So just to get started, there was a Oregon Psilocybin Advisory Board meeting held in Oregon.
Let's do an intro for Lizzie real quick.
Oh, sure.
Then we'll dig into that.
Sounds good.
All right, thanks so much. I'll keep it quick so that we can get into the purpose of the webinar, which is Oregon. I primarily focus on plant medicine matters. I started with cannabis, and as psychedelics are specifically psilocybin coming online with Oregon and Colorado, expanding to assist clients in those areas as well. I have experience with deals in general, regulatory compliance, license applications, contract drafting, and other related regulatory and corporate matters. I've represented clients before various regulatory authorities, including local license authorities, in connection with applications and license acquisitions. I have also assisted clients with conducting complex due diligence and identifying and reviewing and drafting documents necessary for license applications. And last, helping navigate the complex and interconnected state and local regulatory frameworks. So happy to be here and excited to talk about Oregon.
So I thought it would make sense to start just by giving a brief overview. The Oregon State Licensing Agency gave an update at the recent meeting of the Oregon Psilocybin Advisory Board. They have these meetings once every several weeks, and there's this advisory board made up of people from different walks of life who are trying to help the government implement this program and sort of work with the public in complying with these licensing rules. So they gave an update February 2nd. They had a meeting. They said they've received a bunch of applications, but they haven't given out any licenses yet. They're hoping to actually have the first licenses issued, they said, before the next advisory board meeting, which is May 5th. So they've got all these applications, and there's certain delays though that are people are going through. First, the state initially reviews applications for completeness, make sure you have all the different components that are required, the social equity plan, the local approval, et cetera. Then the state has to wait for background checks to be completed of the owners. Then for manufacturers, service centers, and labs, there needs to be site inspections done. And then facilitator license applicants have to go through a training program. Lab licenses have to go through an accreditation process, and manufacturing and service center licenses have to go through a land use compatibility statement process with local cities and counties to ensure that the premises are in compliance with local land use and zoning laws. So all of these factors cause sometimes this to take several months to make it through this process. There's no deadline right now on when to submit the applications, but I think it makes sense to submit them sooner rather than later. Among other reasons, local jurisdictions have a lot of ability to control these, and they might decide that they've reached their sort of limit on how many they will approve. But there's no specific deadline. The state gave an update for facilitator licenses. There's 67 pending applications. None of them are complete. For manufacturers, there's 7 submitted applications. And another 40 that are pending but haven't been completed. Service center applications, there have been 3 that have been submitted for review, another 7 pending in the system. 1 submitted lab application, another 3 started with just the names attached to them, and 20 psilocybin facilitator training programs have been approved, and there's some more waiting to be approved. And then some people might wonder, where are these licenses being issued? How can I see who else has a license or who's submitted applications? Right now, there's no directory of who's submitted the applications. The state will be coming up with a database where people will have an option, but it won't be required to be listed in this database. So among other things, if you're working in this industry, you can see what other businesses are involved and where they are to try to sort of link up with them. The state's also said that it will release this information pursuant to public records requests, at least some limited information. They'll also have a verification system where people can look up whether people's licenses are valid. In terms of a timeline, the advisory committee is proposing some minor changes and adjustments. They said they're going to try to finalize these by August 4th. And then by May 2024, they're going to be considering opening rules up for the bigger policy changes. So this is just kind of the opening structure of the program, but it's subject to change. This is the first one in the country of its kind. And I imagine they'll be seeing how things are going and making adjustments as it goes on. Just a brief summary of the federal law implications. So there's a conflict between federal and state law, as you know, and when there's a conflict under the Constitution, the federal law controls under the Supremacy Clause. And the Supreme Court's held that the federal government does have the ability to come in and regulate these controlled substances within individual states, even if there's no interstate activity, because it's considered substantially affecting interstate commerce. So the federal government law controls, and it has the ability to come into these states and prosecute people. But people are hoping that won't be the case. And I think we have a lot of experience now with cannabis, which is analogous in a number of ways, that's giving people some hope that the federal government will not interfere, but it's still a little bit dicey because this is the first in the country. And the federal government has a long history of persecuting people involved in psychedelics. So maybe they've changed their minds, maybe not. It's kind of up in the air. I know the Oregon Advisory Committee, they've worked on a letter to send the U.S. attorney in charge of Oregon. It's kind of each U.S. attorney has discretion on what types of cases to bring. And it would be nice if there could be some understanding with the U.S. Attorney's Office in Oregon that they're not going to try to prosecute people who are complying with these state laws. In the cannabis space, there's actually some protection against federal interference. There's something called the Rohrabacher-Farr Amendment, passed in 2014, that prohibits the federal government from interfering with medical, state legal medical cannabis, not recreational cannabis. There's no similar protection for people complying with the psilocybin programs. And also in cannabis, back in 2013, the DOJ issued something called the Cole Memorandum that provided non-binding guidelines regarding marijuana enforcement. And it listed certain factors that would be likely to trigger federal enforcement, like crossing state lines, funding gang activities, distribution to minors. That Cole memo was rescinded, but it seems like the federal government's generally been following that, and that the basic guidance is that if people are complying with state laws in strict compliance, the federal government won't interfere absent these unusual circumstances. And that's been the case for a few years now with no Cole memo. giving guidance. The federal government has pretty much been hands off. So we're hoping that stays the same for psilocybin as this rolls out. Lizzie now, I believe, is going to get into a little overview of the different license types in Oregon and the major points in the application process.
Yeah, thank you, Raza. And before we do that, Lizzie, we're going to drop a poll in the comments here. So if anybody wants to let us know what you want to hear about in the future, please do fill that out. Yeah, and Lizzie, what can we talk about in terms of different license types and maybe big questions there by type?
Absolutely. So I'm assuming that most of the audience knows all the 4 license types, but just in case, I'll go over them quickly and kind of a little bit about each one, and then just kind of high level on what you need to pay attention to for applying in Oregon. So there are 4 license types: the facilitator, manufacturer, service center, and testing lab. The facilitator license is, licensed facilitator will support the client through the 3 components of psilocybin services. So the preparation session, administration session, and integration session. And this is the only individually held license. The service center, the only license type where psilocybin may be consumed by a client. The manufacturer license type is where the psilocybe cubensis, the only species of mushrooms allowed by Oregon, will be cultivated and the products processed. They will need to be tested before being transferred to service centers for consumption. For the manufacturer license, the applicant will need to apply for a specific endorsement type, which would include cultivation, extraction, or edible production. And last, the laboratory license, where the products being produced or cultivated by a manufacturer will be tested. They not only need to be licensed by the Oregon Health Authority, but also be accredited by the Oregon Environmental Laboratory Accreditation Program, or ORLAB. So quickly, just for the facilitator, because it's the only individually held license, there are different requirements for the application process, but there are certain things that a facilitator must meet, certain requirements prior to applying. So the facilitator must be 21 years of age or older, have a high school diploma or equivalent, must be an Oregon resident for the past 2 years prior to application, must pass a criminal background check, and this, I think, is maybe why it's taking a bit longer for facilitators to apply, is completing the psilocybin facilitator training program with a curriculum that's been approved by the Oregon Psilocybin Services, the division in the Oregon Health Authority overseeing the program. That needs to be completed prior to applying for a license. And you must also pass an exam from the training program and also from the Oregon Psilocybin Services. So there's 2 levels of exams. That application fee is $150, but once approved, the annual fee is $2,000. So for service centers and manufacturer applications, there are, as Raza touched on, specific location requirements that need to be included. For a service center, the location must be at least 1,000 feet from a school, and the applicant must state this on their application that it is indeed 1,000 feet from a school. And for instance, for a manufacturer, if the applicant is not the owner of the property, then it must get written permission from the property owner to have psilocybin manufacturing business located at the property. The service center and manufacturer applicants will need to have a signed land use compatibility statement, which, as Raza noted, demonstrates that the proposed use of the property is consistent with local land use and zoning codes. The service center and manufacturer and lab applicants will need to also have a map or sketch of the premises where the proposed business will be located. And so you really kind of need to think about where things are going to be located prior to applying, so that you can show the Oregon Health Authority, or the Oregon Psilocybin Services Department, this is where the cameras are located or will be located. These are the boundaries. This is the limited access area. These are all of the doors. This is where the bathroom is. So these are things that you'll need to work out prior to applying. All applications also need a social equity plan, which I'll chat about in just a bit. And then in terms of the license fees for the service center, manufacturer, and lab applications, the application fee is $500, and then once approved, the annual license fee is $10,000. But that may be reduced if the applicant qualifies for a reduced license fee, so it would be $5,000. And as Raza noted, there are a bunch of applications that are pending. So kind of what that means is the Oregon Health Authority will consider an application incomplete if it's missing required information. So then they'll give the applicant an opportunity to supplement that. I believe it's 90 days, and then to basically complete the incomplete application. An application may also be considered insufficient if, for instance, the location doesn't meet the requirements. So, they'll have a site visit, and let's say they see that there is a school down the street that is closer than 1,000 feet away. So in that instance, the application would be insufficient. The applicant will have 90 days to fix that. If they cannot rectify the insufficiency, then the application is denied. So what kind of high level takeaway is, it's really important to understand the components of the application and make sure that you have everything that you need from the beginning. Otherwise, once you submit it, then you're in this, this deadline of 90 days to fix anything that may need to be fixed. So that's just kind of an overview of the license types and application process.
Thank you for that, Lizzie. From what I understand, yeah, to your point about facilitator licenses, I don't believe any schools have finished their first training group yet. So that's soon enough. I think within a couple months, the schools will be graduating people, and people will be ready to apply and take those exams. So it's coming.
That's interesting.
Yeah. Now, Raza, what kind of parts of applications might applicants not be thinking about properly? Any kind of like structuring or anything like that?
Yeah, there's a few issues that it's good for people to think about at the beginning, to kind of being mindful of the bigger picture and some of these unique factors that come from the federal illegality and how to succeed and position themselves in this industry that's really brand new and set up the business for success going forward. First of all, just setting up the structure of your basic business in the beginning. And one issue there is the Oregon residency requirement. The Oregon's requiring that every psilocybin license be majority owned by one or more Oregon residents who can prove that they've lived in the state for a couple of years. And there's questions about whether this is constitutional under the Dormant Commerce Clause of the federal Constitution. But right now, this is the law. You have to structure your business in a way to comply with it. Couple of points on that. First of all, that requirement sunsets, I believe, in 2025, and you're allowed to have an agreement where the Oregon resident agrees to transfer or sell their interest in the business to the non-Oregon residents after that requirement sunsets. So you can structure your business. If you want to have the Oregon resident involved long term, that's great. If they want to just be there for the legally required period and then their interest reverts back to the others, that's fine too. But it's just something you need to think about in advance. Also with the Oregon residency requirement, that's the requirement for the entity that's owns the license. So it's common for there to be management companies that come in and manage these operations. And my understanding of the law is you don't need to be an Oregon resident to be a manager of a psilocybin business. So you can have a management agreement with non-residents that's getting management fees, and those can be based in part on the performance of the business. My understanding is you can do it as a percentage of revenues get distributed as management fees, and obviously the higher the management fee, the less money there is to distribute to the owners via profits. So basically through the management agreements, you can kind of structure the finances to be however the parties that's in compliance with the law. The other issue with structuring the business that you want to think about in advance is with the federal tax issues. Section 280E of the Internal Revenue tax laws, it requires prohibits traffickers of Schedule 1 or Schedule 2 controlled substances, including marijuana and psilocybin. They're both Schedule 1. They're not allowed to deduct their expenses on their taxes. So this means that their tax bills are a whole lot higher than they otherwise would be because they're paying taxes on all their revenues without being able to deduct their expenses. There's some tweaks there that people can do to sort of minimize the impact, including classifying items as cost of goods sold. But one of the main takeaways is that this tax punishment basically applies only to the Schedule I trafficking organization, the entity that's buying and selling the psilocybin. So if you have a separate company that owns the real estate, owns the intellectual property, provides other services that are not buying and selling psilocybin, a lot of times the service centers might have yoga, a cafe selling other food products, other services. But to the extent that you can move as much of the business as possible into these non-trafficking entities, those won't be subject to the punitive tax rules. And it's a way to save money on taxes. And these 280E rules can really be punishing for these entities. So it makes sense in advance to sit down and figure out how you can structure these. And it's helpful, I think, to talk with accountants who have worked in the cannabis industry because they face a lot of these same issues. The other thing that a lot of people aren't aware of off the bat is before you can even apply for the state psilocybin licenses, you have to get the local land use approvals. And having worked in cannabis for a number of years, this is where a lot of the sort of crazy and unpredictable side of the licensing comes in. Basically, local city governments and the county governments for the unincorporated areas, they can set whatever rules they want to for where these businesses can operate. And sometimes those can be extremely restrictive and difficult to comply with. Local governments are also free to totally prohibit psilocybin licenses within their jurisdiction. And they could do that by putting it to a vote in the last November's election. A number of cities and counties opted out of the program, but most of the larger cities have not opted out. So there's a lot of places where you can still do it. But some local jurisdictions, it's as easy as just sitting down and meeting with one of the city officials. They'll sign off on it, and you can have that sign off for the state application. Others make you go through a process that can take several months to get a conditional use permit, it's called, or other type of local approval. Sometimes those involve public hearings with neighboring landowners, community groups, and so forth. So these are really different from place to place, and a lot of times it's hard to find information on the websites of the local governments. You really have to reach out to some of the local officials and sort of initiate the dialogue. And that's good to kind of develop a good relationship early on with the local officials, including if you have attorneys, having them reach out to them so they can get some comfort that you're trying to do this the right way, and that you're going to be a good citizen of their community. So that's something you need to think of off the bat, is which local jurisdictions are going to be the most friendly, and how you can go about that process for getting the local approvals. And as part of that, sometimes it helps to reach out to local community groups, also neighborhood councils, other charity groups maybe, because it can help with the local governments if they see that you have the support of the community. And maybe you can think of things you could offer to the community that might create some goodwill to help with this local process. Just a couple of other points to keep in mind. Opening up a bank account, that can be difficult. Banks have been hesitant to work with cannabis customers because the banks don't want to get themselves involved in violations of federal law, allegations of money laundering. There could even be asset forfeiture of bank accounts. A lot of banks just said, no way, I don't want any part of this. More and more have been opening up to working with cannabis, and I think we'll probably see some opening up to psilocybin, but initially it might be difficult to get a bank account because it's so brand new, and it's there's no guidance from the feds. The feds did give some guidance called the FinCEN memo about how banks can legally do business with cannabis clients. They have to file these suspicious activities reports for any that are violating federal law, but for the ones that they conclude are complying with state law, it's a very simplified process of filing these reports. But the banks have to do due diligence to see if these businesses are legit and following the state laws, at least. Mortgages and leases can also be an issue with due to the federal law. A lot of mortgages have requirements that you'll comply with all federal and state and local laws, and this doesn't comply with that. So in terms of getting the property, you're probably going to have to deal with these issues. There are private entities that loan money to cannabis businesses that are, I think, going to be open to doing loans for psilocybin businesses. But in a lot of cases, it might be hard to get a mortgage or a loan. Trademark is something also important to focus on off the bat, and your brand. And a lot of the people who are successful in the cannabis industry have been able to develop a successful brand, and I think that'll be the case with psilocybin. And to think about off the bat, how you'd like to distinguish your brand, and then legally protecting the brand. You can file a federal trademark application that applies nationwide, but you can't do that for any product that's illegal under federal law. So a lot of times in cannabis, people will trademark apparel or now hemp-based, federally legal hemp-based products. They try to get as close as possible to what they're doing. So when the federal law changes, we think it will eventually, then you can have that federally established brand and transfer that over to the psilocybin itself. Also at the state level, you can trademark, a number of states you can trademark cannabis. I believe you'll be able to trademark a psilocybin business under Oregon state law, but that's just starting up. But you can at least get legal protection in the state of Oregon to stop others from using your brand. And then finally, it's important to just keep in mind the federal laws are changing. There's discussion about federal rescheduling. And if that does happen, that could impact these state licensed businesses. Right now, Oregon is not a medical model. It's they have these service centers, but there's no requirement of a doctor's recommendation or prescription. It's open to everyone 21 or up. At the federal level, they may move it to Schedule 2 or Schedule 3 or lower schedule, which puts it in the medical context. And that could obviously impact these state law kind of recreational adult use industry. So it's just something to keep in mind, keep an eye on how the federal laws might change and how you might be able to adapt your business if that does change.
Thank you, Raza. Folks, if you have any questions, please pop them in the chat. Lizzie, in the remaining couple minutes, would you mind speaking about the social equity program that Oregon's putting in place?
Yeah, so they have the one of the application requirements is a social equity plan, and that is for all license types. So facilitator, service center, manufacturer, and laboratory license. And this is really to ensure that every psilocybin business in Oregon is considering how certain communities have been disproportionately harmed by systemic inequities, and how these businesses propose to address these inequities in their business practices. There's not really a form or page or size requirements, but it's really something for the applicant to dive in and consider how they will fulfill these goals. And some of the goals would be the application of diversity, equity, justice, and inclusion in the licensee's internal practices and policies. And so the Oregon Psilocybin Services Department of the Oregon Health Authority has put out kind of a guidance that has a list of things that you can consider including in your plan, and also links to other areas such as cannabis, local requirements for cannabis companies to put similar plans together in their applications, so that the applicant can kind of see what's out there already and maybe pull some information from there. But it includes components such as considering goals for measuring and achieving diversity and ownership, for example, and how any workforce training and investments will further justice, equity, diversity, and inclusion. And this isn't just a one-time requirement. So it's not just you put it in your application and you're done. At renewal, the licensee will also have to provide documentation showing their evaluation of how they've implemented these plans. So it's really an important step, and I think that it would be helpful for applicants to create a clear and thoughtful and actionable social equity plan, so that they can achieve some of these action items and demonstrate that to the Oregon Health Authority.
Thank you, Lizzie. We got one question. Where can folks find those sample ideas for social equity plans?
So that is located on the Oregon Health Authority's website. When you click on, they have a lot of guidance for each application. So each application type has its own basically website. Under that, there should be a social equity, like kind of at the very bottom of the page, a social equity link. And they also sent an email out with it, which provides you kind of with a list of consider this, and then also check out all of these other social equity plan requirements from these various states and local licensing authorities, and to be able to craft yours and really think about what you should include.
And I would just add to that over the past several years, a lot of cannabis licensing jurisdictions have also had this social equity component and had this requirement to submit social equity plans. So if you can speak with anyone who's been involved in cannabis licensing, there's probably a lot of already very good plans out there that apply to cannabis that can be modified to apply to psilocybin, but people have already thought through these issues and come up with plans in the context of cannabis.
All right. Well, Raza and Lizzie, thank you so much for all of this. I think we'll end right about on time. If folks want to learn more about what we do at Psychedelics Today, come visit us, psychedelicstoday.com. We have a big podcast and education presence, and are about to launch a 12-month training program again in April for our second time. Raza, Lizzie, any last thoughts?
In terms of, I would just throw it out there for the application process, just have a plan and plan ahead. So make sure you have all your ducks in a row. And if you need assistance with that, we're happy to help, but it really will cut down the timeline of the application process and the possibility that you may have an insufficient or incomplete application. So really planning ahead and understanding who needs to be disclosed in the application, getting all of the attachments to the application ready, and everything in like a nice package to present will help move things forward.
And I would just add that while it's important to focus on the details of the Oregon application itself, try to think in the larger context about how your business can be successful going forward. Over several years, there are a number of other states that are considering legalizing psychedelics, including Colorado, which will probably start issuing licenses next year. And try and think about how you can position yourself to take advantage of this as the opportunities spread out across the country.
Great. Thank you both. And if you have any questions, please reach out directly, perhaps on LinkedIn, or the attorneys over at Super Law. They will likely be very happy to talk to you. So, all right. Thank you, everybody, for tuning in today, and we'll see you on the next webinar.